Good afternoon, 3 p.m. It is our normal Saturday knowledge exchange time. And we remember as a CPA firm, we have clients coming in and we know what their issue is. And I want to bring up this probate, the word of probate. It's just because there's quite a few cases coming up and the folks are really worried about, now, I'm an orphan. And what do I need to do? And so let's just kind of breaking that down. I know it is a huge topic, but what I want to do is I want to show you what exactly probate does for you. Like at what point of time you are going to speaking the word of probate. Normally you won't speak the word of probate. If you are having a happy life, nobody passed away. But if your mom and dad passed away, and they didn't have will, or they have will, but they did not have a trust. They didn't have anything special. They're just normal people, like John's father, and it just, normal working class and passed away, then what do you do, right? So those are the things, doesn't need to be blown up like a huge event, but we also want to make sure that you understand what exactly John is doing when his dad passed away in March of 2025. So let's go ahead and do that. How probate works. Before every of our webinar, give me a minute and a half. I want to go through our firm just because I want you to know about our firm. So when you run into situations, you don't have to think really hard, and community CPA will pop in your mind and you will naturally contact us. So this is our page, our website page, communitycpa.com, and you can see we are right now, our front page is about this OBBBA on individual tax planning. It has somewhat to do with probate. But again, OBBBA did a lot more things to estate side of the world, and we're not doing that today, but we are going to talk about probate, okay? All right, so that's a list of things to impress you about our firm. I want you to know that we speak more than 10 languages in our firm. If you want to remember one thing about us, and we speak multiple languages, and when we hire professionals, if that professional can speak another language, it is not liability, it's asset for us. We like to hire people with different languages of capabilities. And with that, let me go to this page, which is YouTube channel. We have a YouTube channel, yes. Our YouTube channel is also a do-it-yourself channel because we are not there to advertise our firm. We're really, in this channel, you learn. And you learn what we do and what you can do, so you can do it yourself. That's kind of the idea for having a YouTube channel. And I know some folks were telling me that they're professional, they're bookkeeping companies or they're CPAs at a CPA firm, and the staff actually come to follow our channel to learn what we say. Then they go back to talk to their companies, other CPAs, and then they show up like genius because they know a lot of things. And we do have a lot of clients, so our knowledge, our topics are very timely. And you will realize that the topic we talk is sort of like, oh yeah, it's exactly what I want to know. Why do we have those topics? Is because we gather 12,000 clients' information. What they ask become what we talk about. Makes sense, right? And that's the 2 books I wrote, and you can find them on Amazon. And this is disclaimer to say that you need to take the content objectively, okay? Grain and salt, and don't just blindly believe anything audio out of the internet is true. Of course it's not true, right? And you have people lying day in, day out with so many things. I have never ever believed someone would lie like what our president does. Oh my God. Well, that has to be a disease, right? So I believe that all humans are divine, and if we are not, if we are evil, we are having a disease. And let's just doctor do that work. It's not our job, right? Okay, so let's go ahead with this real content we have here. What is probate? Probate is a legal process of transferring assets from a deceased person, a dead person, to the heirs, to their children, to their related people. So that is the legal process. Obviously, probate is handled by the lawyers, handled by executor, which can be the family member, but you have to follow the legal process that the lawyer would guide you through in the probate. It involves a formal court supervision to validate documents and oversee the distribution. When they say validate document, they're talking about wills. So that's why sometimes people go, oh yeah, my estate is good, I have wills. You have wills only means that when you go to probate, one of the steps will be taken, which is to validate your will, make sure that it's not made up will, right? If you happen to be drunk one day, wrote several wills everywhere, and then that would be a problem. And people, the court would have to decide which will is the right one. Then, in this case, when you say, oh, I have a will, I'm good, I don't need to go through probate, you're wrong. You still go through probate. The only time you don't go through probate is because you have a trust, right? We have webinars on our system to lay out how to work the trust, but this is just to say to people, when you have a parent who don't have a trust, and you as a child receiving their estate, but you have to go through the probate process to get their money, that is the people that we're talking to today. And this process begins once the person passed away. So you can imagine, in John's case, and his mom passed away quite a few years ago. So he was the only child in the family. So he was with his dad. So dad passed away in this year, March. So he became an orphan, right? He's no longer, he's 58 years old, but he's orphan. Mama, dads are all gone, right? So in this case, what would John has to go through? Let's look at this chart. I borrowed this chart from Alicia. Here, Alicia Reed is from Thomson Reuters. So here, let's take a look at the key steps in the probate process. Number one, the person passes away. So that's John's dad passed away in March. Probate case is open at the courthouse. So John went to Iowa courthouse, opened up the probate. Executor is appointed, and in this case, John actually submitted a petition, I believe, application to become the executor, because it is possible that the executor is actually the family member, okay? And then the probate process is to find asset and the debit, and and the debts, which you need to find what John's dad have, what John's dad owes to other people, and figure out what money John's dad is owing, right? And then maybe there's a will to be produced, or maybe not. So normally that's a probate process too, to identify the will. So in John's case, there is no will because, that probably in his mind, he assumed everything gonna be John's, like that. And then the remaining asset distributed to beneficiaries, in this case to John. So you see that process. So you open up probate. Of course, in Iowa, if it is less than $50,000 in total estate value, then you don't need to go through the full-blown process. But John's dad estate is $1 million, so it didn't need to go to probate process. So this is kind of the big picture. the person passed away, then you open the probate. Once you open the probate, you will have a probate lawyer, and you also will have executor. This executor can be a family member, can also be a court-appointed person. If in case Zhang is not available, right? Then starting from there, executor would be the one that looking for the property, looking for how much money that owes to other people. And a lot of times, if there is no help, the court actually posts that on newspaper, saying that who and who died and how much money did anybody did this person owe anyone any money. So those are public publication goes out. Then is will, and you need to produce will so the court knows how to divide. Otherwise, court gonna divide it for you without your will. All right. So now, a lot of people will tell you that they don't like probate. They don't like probate process. And I summarize the reasons for you. The probate process is often described as extensive. So expensive, the legal fees, the court fees, appraisal fees, especially if you have a business, that appraisal fees will come in, right? Because they have to determine your value. The calculation of probate fee is also by the value of the estate, so there's no way they're not gonna do that. So they're also, because of all of these things, so it's a long and drawn out process. So you could take significant time to get that finished. And because of all these publications, it's a public knowledge once it's in the probate court. So people knows that that person has how much money, right? And the court filings exposes the personal information, the name of who gets the money, how much money there is, and the personal dispute. If the siblings coming out and they start fighting over, then it will be a lot of legal fees. So I'll give you two examples of these kind of complications in probate. This is high-profile people, and you know them. Aretha Franklin, also Chadwick Boseman, right? And the guy who played Black Panther. Aretha is actually a singer. So people call her Queen of Soul. So she has certain songs. She died before pandemic. So it was the time that I'm not familiar with her songs and famous songs, but she did have some pretty known hits, which I'm not sure. I think I know one of the songs called Natural Woman, and that's one of her songs. And I don't know the other ones, but she's pretty well known. She passed away, so the problems with her probate, obviously she is on probate, she goes through probate process because she has no trust, right? She didn't set up trust, so she's going through probate. The problem with her is she has multiple wills. She has one found in 2010, written in 2010, okay? So she put that under a locker and with a key. Then the other one discovered, which is written in 2014. So she passed away in 2018, so it's like 4 years before she passed away. And she put this will in the cushion, in a couch cushion, and the signature of her is a smiling face. So that lead into a lot of dispute, because the earlier one, the 2010 will, that one favors the older children. The 2014 favors the younger one. So this whole event drowned out, and it is taking 4 years to close the probate. And she paid 30% of her estate for the legal fee. And her whole estate is 80 million. So 30% of that, we're talking about $24 million was paid to the lawyer, to the probate lawyers. So that is, that is an issue when you have the estate, you have the money, but it wasn't really properly arranged. having multiple wills and just causing 4-year-long battle to figure out how to do with her will. At the end, the court went with the 2014 one, the one with smiling face. Chadwick Boseman, the Black Panther, and he did not even have a will. So no will at all. So it's all left with the court. And then because he's a California resident, so his whole proceeding was under California state law. So let's just take a look at what he did. He didn't really have as much money as Franklin, and his whole estate is about $1 million. So let's take a look at the fee. So this is where it is. So Aretha Franklin's fee was $24 million attorney fee and plus other fees. So she paid $11,000, almost $12,000 on inventory fee, and of course court filing $200. So this is all the fees that she has to pay out of her estate. So she has $80 million, and minus all these fees, the rest give to the heirs that she wants to give to. Then Chadwick has about $1 million in estate. So I broke down the fee that he paid. He actually paid $46,000 combined to distribute his estate. So it's quite a fee, when you talk about probate. But if you have a trust established, for example, if Aretha Franklin has a living trust, and then the living trust will lay out on how to divide. Then all these attorney fees and all of these struggles with different wills will be taken care of in that living trust, and she'll be concentrating on that one living trust and plan it out. So can you imagine $24 million is a lot of money to save. But I do understand when we transition generations, like a mom and dad transition money to the children. And from the children's standpoint, they are just happy with whatever money they received. They actually do not have the same feeling and attachment like the parents who made $80 million, now pay $24 million out. That's a lot of payout. And if the parents are alive, they would never let the children to take the balance of the fund. They want the $80 million all goes to the children, right? So I say that because a lot of time I deal with parents' generation, then I deal with children's generation. But when come to estate side of things, the parents really trying very hard to get estate, not to spend money, so all the money goes to the children. But when come to the children, sometimes when they are not knowing, they don't have the same value thermometer, I guess. It's the feeling of the value. They don't have that as strong as the parent. So they kind of feel like, okay, fine, $24 million can go to the court. I just get the balance. That disconnect, it is really where I think a good planning can save money. And you want to know that your children, if you're the one making money, like our small business owners, you're making money, and I will advise you, your children would not even blink to pay the $24 million probate fee. They would not blink because they don't know how to get away from that, and they also don't know the value. They know that they're still going to have a lot of millions. You got 80 million and 24, and you're only like 50, you're going to left over with 56 million. That's great. So the kids were happy with 56, but really they should be getting 80, right? So as a parent, and when you are still kicking, you're still alive, and I want to make sure that you arrange these things so the kids would not suffer from cash shortfall. Because there are also cases we come across, the children has to sell. Children has to sell properties to pay for the probate fees. So it can get very, very sad, because those properties are the one you don't want them to sell. You want them to continue make money out of it. So asset type commonly go into the probate, through probate, are solely owned real estate, real estate property appraised and going through probate. Personal bank account without beneficiary. If you have a stock investment account, checking account, saving account, you don't have beneficiary, they go to probate. And then no transfer on death paperwork and no payable on death designations. Those are things goes to probate, because if you have a transfer on death certificate with certain properties, if you have that, then that property doesn't go through probate. It's just gonna go because it's transfer on death. A lot of time when you have a living trust, the trust document itself will have transfer on death, payable on death designations for you, so you don't worry about things that you forgot, right? And asset not held in the trust are all goes to probate. And there are cases I have seen the living trust wasn't updated for years and years. Then parents passed away, literally forgot their baby boy that was born later on. So, in that case, some of those assets, some of the beneficiary are not on the living trust. It's just causing the process to be very complex, because you have to go through probate for a piece of it, then you go through your living trust. And if your other siblings are not fighting over things and thinking that the trust was just not being updated. So we always recommend that if you have a living trust, you want to update your living trust when you do your tax return. Every year you do tax return, right? Just make that a mental habit. Whenever you are doing taxes, and you will just come to your tax folks and making sure that the living trust has been added on. If you bought new property, you got new baby, God knows what is new. So you can add into your living trust and don't make the trust going outdated, right? So those are the assets typically going through probate. And the responsibilities of executor. Remember, like when you open up probate, and the court will appoint the executor, and this person is responsible for gathering all the things and giving to the court. So that could be a family member. So here I put in here that executor appointed by court can be family members, and the probate lawyer work with the executor, work with the family member. The executor manages the estate, the attorney manages legal process. So that's how you work with the probate lawyers. And of course, in terms of you as executor for the probate process, for the probate, and you are the one locating the inventory assets and identify what's in the estate, and you notify creditors and publish legal notices. You need to tell people, maybe your dad, maybe John's dad owed his brother some money. So those are the things that the executor need to find out. And pay outstanding debt. So if dad's house still have mortgage, and maybe it is time to pay it off with the rest of the money John has, so pay off the loan and follow legal procedures for asset distribution. John is the only kid, so he can get everything. And file validated will with the court. So if dad has a will, but in John's case, dad didn't have a will, so there is nothing to file with the court. So how probate would impact John, impact heirs? So it creates a delay, right, in receiving inheritance. And it can generate conflict between family members. Well, in John's case, there's no complications. But what if John's father adopted a child, and then it is not, nowhere is named that child as heirs? So that could be a conflict. There's a famous case in California where the parents has 2 biological children and 1 adopted son. When they were sick, so this adopted son was so kind. He take care of them, and basically, is the one. The 2 kids never really cared about the parents, but the adopted son is the one taking care of the parents all the way till they both passed away. But the living trust they have, did not give any money to the adopted son. So that was brought to court. The result is the court actually allowed the living trust, the wills, to go with the way it is, did not give the adopted son. So, this is what I read quite some time ago. So the judge said that, for the mom and dad to adopt you, bring you to this good life in United States of America, that is already a life gift, right, for you. And so, the court hopes that he would not dwell on inheritance, because what he has is really the good life for all of his youth. And the mom dad watched him, he sent them to heaven, but that's really that's enough. That's enough of a money and a good deed the parents did. So he didn't get any inheritance, but he did sue to believe that he should be treated fairly like a family member. See, all of these, right or wrong, it doesn't really matter. The matter is that your will has to be clear, because the parents were so clear to make sure that the adopted child do not get anything. So the court followed what is said in their document. So the will is will. Even if it is not fair, that is still the will. So you want to make it clear, don't create multiple copies, and then who knows what's gonna happen. And or even write different wills at different time, and just because your mood is different. So as a small business owners, and we want to make sure that we as a person do not contribute to complexity of the future life for our children, right? You want to make it simple, make it straightforward. Okay. Of course, the probate makes family matters part of the public record. That is the worst part, in my opinion. And that just blow open whatever argument you have among your siblings is all in the open. So there are non-probate assets. Assets that go through probate, like I said, individual owned properties, the bank account and all of that. Assets that avoid probate are jointly owned property. So jointly owned, so maybe the person died and then you did not die, but two of you jointly owned property. That doesn't go to probate. Asset with named beneficiary, like 401k plan, that doesn't go through probate, right? Asset titled in trust. See? So if you have all your asset titled in the trust, then you don't go through probate. Makes sense, right? So just make sure that you understand why people are doing trust. So John's probate steps, I do want to kind of come back to this example we have and what John need to do. This is the real reality. So John opened probate with Iowa court because his dad's estate is more than $1 million. So if it is under 50,000, John don't need to open up a probate in Iowa court, because Iowa has a special, it's called a simplified probate. I don't know, I forgot the name. There is a simplified way. You don't have to do anything. It just, it is no need to follow these procedures we were talking about. But John has, because the value is more than 50,000. And some money his father had was in his 401k. So it is already have John's name as a beneficiary, so never need to go through probate. So what John did is he took that death certificate, and then he submitted that. Actually, he has an agent. He has an agent who works at Fisher Investment. That's where Dad's 401k account is at, with the company that he retired from. So then that got faxed over, and then Fisher Investment received the document and put change the stock account, the full account. I guess it's not changed, but it become his name and his social security number with a step up the value. Step up value just means it's the date when the stock market, when Dad passed away, and how much the market value is. So let's say if the market if the stock was bought for $1, the market value was $10. So normally there's a $9 capital gain, right? But in this case, John don't pay that $9. And John just go ahead, start his stock account as a $10 as the base. So that's what we call the step-up value. So that was all done. So John did that himself. And it doesn't really need any lawyers or anything. You can just deal with the 401k agency and get that done. And his dad has a stock investment account. It has no beneficiary was ever listed. So that one went into probate. And imagine that if this account has John's name, then it would not be the same. So, but this one didn't, so it went to the probate. And the probate closed. That passed away in March. Probate closed in September. So that account was like open, still actively trading by the agency and up to September 2025. And John will file a short year. So this is what John need to do. John need to file taxes for his dad from January to March. This is a short year 1040 final return for dad, right? And in here, the capital gain that make on the stock market is still going to be reported on the Schedule D as a capital gain. And then John will file a 1041 while the estate was open, because that stock market, that stock account still makes money. From March, that passed away all the way to September. So that income will be reported on 1041. So John will file 1041 estate return for a short period of time because it's closed in September. So in 2025, he will need to file that 1040. He need to file 1041 to cover from March to September. And then he also need to file his own tax return, right? His own tax return, he's going to take over that's the stock account. And remember, the stock account already stepped up, so he will start filing the gains from $10 to whatever dollar, or maybe a loss, right? So that will be reflected on his Schedule D. So that would cover from October to December. So you see how this, it is a lot of filing for a very short time, but it's not confusing, right? We want to conclude that, and then we want to cover the period that died, but John didn't take over. Then you will file John after he took over, right? All right, let me show you this one. This is also, I stole from Alicia's picture because I thought it's just really nice. It's from Thomson Reuters. Okay, so benefits of trust, and you can see that the benefits from having a trust is avoid probate. So you can see we talked about a lot of probate. Like it or not, that is the nature of the beast. So if you want to avoid it, that would be one of the benefits for having a trust. And a spendthrift prevention. This is the trust can be an instrument to manage how money is going to spend. So that's very powerful. When you have a trust, for example, if you have a trust for your children, and the trust, says that distribute income to my children after they turn 30. Then before that, and that trust is you taking the money. So after that, it goes to your children. So trust is such a creative instrument, and you can embed a lot of things and extend your power beyond your life. And that is really the power of trust. Asset protection, absolutely. Not all the trust is asset protecting, but irrevocable trust absolutely is asset protecting. And the minors can own the trust. Of course, you can have an irrevocable trust, and so your kids, they're minor, they're already beneficiary, but while you still live, you're grantor, so you can always manage the business, the money, whatever you want to do for them. So they're the owner, but you work for them, right? And reduce gross estate. That is another thing. You know how there's an estate threshold, right? 13 some million per person, and now it's big. But back in President Obama's time, and it was only 3.5 million. So that threshold is sort of soft. Depends. I think the OBBBA made it permanent. You know how many executive orders President Trump is signing, and any president can come to that spot and signing executive orders and getting rid of anything you have. So I would never look at any tax laws and regulations threshold to be permanent. But the key is that for a tax strategist, someone like me, I am very much present. If today you can get benefit more, you don't look for tomorrow to get 50% of more benefit. No, you don't look that far just because there's no guarantee. Anything doesn't disappear from executive orders. All right, so with that said, these are all the benefit of trust. I know they don't relate to one kind of trust, but they are there. So if you say, wow, I just want asset protection, I want to use trust to create asset protection, then people will come up, the lawyers, the CPAs will come up with the trust for you, because those are all the benefit the trust can create. All right, so if John's father has a living trust created, do you know what John would do now? So he will not open up a probate, right? He'll handle 401k the way he was handling because it has him as a beneficiary. Then the rest of the account, and he is a trustee of the trust, and he'll just do exactly the same what he did for 401k. Fax over the death certificate and identify himself as trustee, and then it's giving to the beneficiary is himself. So it's just that straightforward, that simple. No probate fee to pay. The only thing to pay is him paying himself without paying any money to the court. So in John's case, he paid about $33,000, right? So the Iowa has this court fee, inventory fee, and the lawyer fee. So there's not much of a lawyer charges. So it's $33,000. With that said, you see, if he has a trust, he'll be avoiding that probate charges. Why probate planning matters? It is, I want to say that if you don't want your heirs and your son, your daughter go through what Franklin got her children going through. And they lost $24 million. I don't think that's fun. So then you want to make sure that you plan your estate. So probate really, if you plan your estate, I would rather you do a living trust planning, and then know that probate can break up your business ownership. Probate can force sell your real estate because if you don't have enough cash to pay, and probate will make sure that you pay your debtor, and so they can distribute your wealth, right? They can drain your wealth. They can cause unnecessary conflict. So probate is a ugly animal. You try not to expose yourself to it, okay? Proper planning can prevent probate exposures to the public. I hope this short talk really gave you some ideas about how probate works. And this is our partners at our firm, and you can book our time. We can give you a video consultation session. And I also want to let you know that our office open from Monday to Saturday every week, Monday to Saturday, 8:30 to 5:30. So we are 6 days a week professional firms, and you got our number here, 515-288-3188. And if you have any questions you'd like us to teach here so you can do it yourself, why not? You email Catherine at communitycpa.com. We will do that for you. I will talk to you again and appreciate your time. I'll see you again. Bye-bye.